the topic that is patent infringement. Patent infringement is one of the important act in the patented products and processes which are working across the globe. The someone who allegedly known as an infringement, who infringes the patent rights of the lawful owner of that particular technology without his permission could lead to a serious consequences. Under that, patent infringement is a commission of prohibited act with respect to patented invention without permission from the patent holder. It further demonstrates that the technology or the inventions of making, using, selling the invention without the patent owner's permission is not permitted by any domestic patent laws, and that could lead to a infringing of patent infringement. There are two types of patent infringement. One is direct infringement and second one is indirect infringement. Direct infringement is nothing but it directly states that the third party has fully or intentionally stole the technology from the inventor without his prior permission. It occurs when someone directly makes, uses or sells the patented invention without the permission of patent holder in that particular country, and particularly it includes the manufacture of patented technology, use of patented technology, even offer of patented technology for sale, then the import of patented technology and pass of patented technology. Further, when it comes to the indirect infringement, it is the unfair practice that does not a clear indication that the patent is bought or sold in the market. But for instance, when a device is claimed in a patent, the third party supplies the product which can only be reasonably used to make the claimed device. So it is not a realistically direct infringement, but there are certain products which are sold by the third party which is unintentional, but it could lead to the sale of the patented products into the market, cause the indirect infringement. So when we are talking about the basic features of patent infringement, then we have to consider the object of infringement, then the infringement behavior, and along with the violation of legal rules. And infringement activity only being proved when the patent must be valid, or patent must be whatever the patent which is being violated, that should be valid patent. So the term or that particular patent is in force. Then infringer must infringe with the purpose of operation or production of that particular patented technology. So intention has to be proved, and the behavior which is carried out without the permission of patentee. So whether that infringer has taken the reasonable efforts to take a permission from the patentee. If that is so, what are the reason that that particular patented inventor has denied the permission, and then that particular infringer sold out that particular product into the market? So that has to be judged. Unless and until these features or the conditions will not fulfill by any patent, then it would not be considered as a patent infringement. So these are the very important basic features of patent infringement. When we came next to the consequences of patent infringement, definitely it causes the huge commercial loss for the any patented inventions or that particular organization, company who are selling that particular product. Then there is a violation of law. Again, that violation of law also could lead to disturb the competitive order of that particular products into that particular domestic market of that particular country. Then even it also damaged the economic laws and whatever the trade agreements between the countries which are there, that has been hampered and seriously deteriorated, or there is a significant impact on the economical affairs of the between the countries. There are certain judgments which are doing while judging the patent infringement by the judge into the court, generally the patent courts or the federal courts or the high courts of the different states and the countries. In that, while judging the patent infringement, it should be seen that the doctrine of equivalence, then doctrine of complete coverage, then doctrine of compromise, doctrine of estoppel, then the doctrine of superfluity, that has to be considered in this particular patent infringement. And after judging this particular infringement, that is solely from the claims of the patent, under that what is the preamble, what was the transition phase, and the main claim portion, that is the characterized part of the patent claim, that is the embodiments of the patent claims, have been thoroughly judged, and these particular doctrines are evaluated to judge the infringement. The very well known cases which has been there, that has been famous into the in the world, that is nothing but the Huawei, which filed the lawsuits in Germany, France and Hungary against ZTE for the violation of their LTE technology. Then Apple sued the HTC for the infringing 20 Apple patents related to iPhones by using the interface and underlying architecture and hardware. And even the Nokia sued Apple for the violation of 10 patents which related to the wireless technology.